There is some correction, give it, please. Writ petition has been allowed. There are some judgments. You have to finalize the pension and before that regularize the period of suspension. Those recovery orders have been set aside.
Right, Vijay. Well, item number 19, Lordship yesterday permitted us to file an additional affidavit. Yesterday we filed it. I am praying for bringing it on record.
Yes.
Lordship, I beg your Lordship's pardon. For listing of a matter, Lordship, we have filed IA, Lordship, for modification of order. So on any date, Lordship, if possible on 12th of June, I'm pleased.
May it please your Lordship, I beg for a listing of an item, WBC 316/25. The petitioner are enjoying the stay, Lordship. Lordship may
You please make a request to the registered bench, you will list it.
problem.
May it please your Lordship, I beg
Yes.
for listing for withdraw the matter, Lordship.
When do you want it?
Tomorrow, Lordship.
All right.
Oblige, Lordship.
Yes. You want to withdraw?
Withdraw this case.
Why you want to withdraw?
One of the respondents are verbally promised
Huh?
they will pay something.
I am not hearing anything.
The respondent verbally promised the petitioner. They will
Acha, you take down. Mr.
pay quality.
K. Kolital and counsel for the writ petitioner submits that he has instructions from his client not to press this writ petition.
He has
Therefore, the
given a
writ
written-
petition be, huh?
He has given a written undertaking to the department that he is withdrawing matter.
Writ petition be disposed of on as not pressed. Mr. R. Dharlane, additional senior government advocate Assam is present and does not have any objection to the state. In view of the above, this writ petition stands disposed of as not pressed. Is there any interim order here?
No, my
All right. Yes.
Lordship, I want to withdraw this petition, Lordship. Yes,
Withdraw.
docket, yes.
Why you want to withdraw?
Petitioner want to withdraw. Petitioner want to.
Same order, Mr. D.P. Bora and Miss, your name please?
Hey, go, Lordship.
A. Gogoi.
May it please your Lordship, at the instructions to withdraw with liberty this petition, my lord. It's a certain developments, my lord.
Mr. R.S. Mr. Counsel appearing for the writ petitioner submits that there are certain subsequent developments connected with this case, as a result of which the writ petition needs to be withdrawn with liberty to file afresh after incorporating the subsequent developments. The prayer made by the petitioner's counsel has not been opposed by Mr. T.C. Chotia, learned additional senior government advocate Assam, appearing for the state. In view of the above and on the request of the petitioner's counsel, this writ petition stands disposed of on withdrawal with liberty as stated.
Municipal notice was not issued.
Yes,
Directed to obtain instruction, but we have not received the instruction. The promotional matter, my lord. Notice may go.
promotion will issue notice.
Yes.
Yes. You right, heard Miss P. Devi
And
and Burman, direct counsel appearing for the writ petitioner, peruse the averments made in the writ petition. The grievance of the petitioner pertains to a failure on the part of the authorities to rectify certain defects in his service record coming in the way of consideration of his case for promotion. Mr. T.C. Chutia, learned additional senior government advocate Assam, prays for some more time to obtain instruction in the matter. In view of the above, issue notice of motion returnable in 3 weeks. Since Mr. Chutia has appeared and accepted notice for all the respondents. All the respondents?
All
No.
the
For BTAD also?
BTAD,
Okay,
Okay.
for all the respondents, no formal notice is required to send in this case, extra copies of the writ petition.
five, except five.
There's the 1 to 4 and 6, and Miss R.B. Bora, then it's SC for respond number 5, service of notice is deemed to be completed. Extra copy of the writ petition requisite in numbers be furnished to the learned department counsel so as to enable them to obtain instruction. Register to list this case again by reflecting the name of learned counsel for the respondents in the cause list. Yes,
Date may be fixed, my lord.
after 3 weeks.
Oblige.
Relates to compassionate appointment. My name has been recommended by the DLC. I am challenging the impugned OM, my lord. Last week, people lost just passed Miller order.
The petitioner as a father died 2008. TLC recommended 2022. In the meantime, that certificate has come and is still in force.
Hmm.
So at this notice may go, other department is there, agriculture department is there. So
No,
what is
but
the
delays because of your,
a delay because of, yes,
yes,
definitely.
then how can you blame the
But
petitioner?
notification 18(9) say,
Hmm.
whoever may be, what is the delay in a part of the official or in the part of the application,
Hmm.
that will be covered by this
But
notification.
then his case was pending.
Pending,
Then is it not covered by the judgment order dated?
not
4th?
judgment, notification.
No,
18
no, the judgment of the coordinate bench, 4/3/2025.
Yes, yes, yes.
It says all pending cases will be considered.
Of course.
Then,
Yes, yes, that is true. You file before the and challenging these notifications. Lordship can be disposed of.
Mr. Chutia, these are very, you see, these are people, marginalized people. They
Yes.
are having hopes. You have to give a convincing answer to them. Whether you give them appointment or not, your answer has to be
The
convincing.
official there, what? 2008, he submitted
Then
application.
that is for you to look into. You have to see how your system is functioning.
Yes, my lord.
If an application of 2008 is considered in 2022, you can't blame him. You have a scheme where you are appointing people on compassionate ground. They are coming because they are in distress. You have to give them an acceptable answer.
Exactly, my lord.
You can't say that, sorry, you are late, where this is
That's
over,
why-
that is over. That will not.
Yes, that's why we are facing trouble to submit before your lordship, my lord, in the court.
But you must advise your clients that they must adopt a fair and transparent stand. I have seen that these are all very, very,
Yes, yes, my lord.
and you are lucky to get away. Beyond that, I can't say anything. You are very, very lucky to get away with 18(9) with this order.
Yes, my lord.
There could have been bigger problem. So deal with their grievance. Give an answer which is acceptable, which is legally tenable.
The SLC
You
also.
may decide not to give them, but your criteria has to be fair, transparent, and non-discriminatory. Some people you are appointing, some people you are not.
Not a
Nobody knows why it is being done. Heard Mr. N. Sharma,
no uniform
learned
for
counsel appearing for the writ petitioner, also heard Mr. T.C. Chutia, learned additional senior government advocate Assam appearing for the state. The grievance of the petitioner pertains to rejection of his case for consideration for appointment on compassionate ground. Full stop. The father of the petitioner, who was serving as jute field assistant under the district agriculture officer, Borpeta, died in harness on 19/4/2008. Full stop. After the death of the government servant, who was the sole breadwinner of the family, the petitioner had submitted an application on 29/9/2008 seeking appointment on compassionate ground. Full stop. Wide resolution adopted in the meeting of the district level committee (DLC) Barpeta held on 7/12/2022. Petitioner's case was recommended for appointment on compassionate ground. However, despite the lapse of several years, no decision was taken by the SLC in the matter. Full stop. It was only on no decision was taken by the SLC, as a result of which the matter was pending. Full stop. However, in the wake of the office memorandum dated 18/9/2024 issued by the government of Assam, imposing a complete ban on appointment on compassionate ground, the petitioner's claim has been extinguished. Full stop. Aggrieved thereby, he has approached this court by filing the instant writ petition inter alia assailing the OM dated 18/9/2024. Full stop. By referring to the recent judgment of a coordinate bench rendered on 3/4/2025 in WPC number 348/2025 and the batch of connected writ petition, as well as the subsequent order dated 28/5/2025 passed by this court in WPC number 2849/2025. Mr. Mr. Sharma has submitted that the case of his client deserves to be considered by the SLC in the light of the observations made in the judgment and order dated 3/4/2025. Full stop. After going through the judgment and order dated 3/4/2025, I find that although the learned single judge has clarified that the observations made therein would not lay down a binding precedent, yet there are certain directions and observations which would have a relevant bearing in the outcome of the present petition. Full stop. In view of the above, and considering the view taken by this court in the order dated 28/5/2025, I am of the view that the matter deserves consideration by the SLC. Full stop. Next paragraph. In the judgment and order dated 3/4/2025, the learned single judge has made the following observations in paragraphs 9 and 10, which are reproduced herein below. Full stop. Having regards to the peculiar facts and circumstances of the case, and for the ends of justice, I am of the view that the petitioner's case deserves to be considered in the light of the said observations. Full stop. As such, his writ petition is being disposed of at the stage of motion hearing by providing that the petitioner's case be considered by the SLC in the light of the observations made in paragraphs 9 and 10 of the judgment and order dated 3/4/2025, and appropriate decision as may be permissible under the law be taken in the matter. Stop. Whatever be the outcome of the process, the same be intimated to the petitioner in writing without any undue delay. With the above observation, the writ petition stands disposed of. Yes.
Yours is similar, only district is different.
Similar district is different. And Mr. A.
And
Chakraborty.
department is department.
Department is different district. Just make these changes, sir. No.
Understood.
Yes.
Petitioner is presently serving in the Assam Rifle, my lord. He is deprived from the promotion to the rank of Naib Subedar, my lord, due to the lacking of their ACR, my lord. The legal notice was issued to the department, my lord, and they replied as annexure 2, my lord, page 18.
We'll issue notice at this stage. You are appearing for?
Mrs. A. Gayan Lordship,
And she is appearing for?
CGC Lordship,
Alright.
all the respondents.
I heard Mr. V. Kumar and counsel appearing for the petitioner, peruse the averments made in the writ petition. Being aggrieved due to denial of promotion to the petitioner based on uncommunicated adverse entry in the ACR. The instant writ petition has been filed seeking a writ of mandamus. Full stop. Miss, I'll record her name.
Lordship,
Miss A. Gayan, learned CGC prays for some time to obtain instruction in the matter. NOM 6 weeks since Miss Gayan has appeared and accepted notice for all the respondents. No formal notice, extra copies.
Detail.
The seeking regulation in fish fair. My lord,
What is this?
Lordship has fixed certain items on 11th. This is seeking regulation in fish fair.
11th.
Paid for.
11th of this month?
Yes.
Yes.
10 to 18, no?
I may be allowed, my lord. Item 10 is also similar. my lord.
Okay, then we'll fix 5 and 10 on 11th. It have done in 5, you write, Mr. P. Had Mr. P. Haradwaj, learned counsel for the writ petitioner. There was the amendments made in the writ petition. The grievance of the petitioner pertains to failure on the part of the authorities to regularize his services despite having worked continuously for, in item 5,
My lord, this is 11 years, man.
11 years. And in
And-
item 10,
Item 10 is 30 years.
30 years, just check it once. Mr. Bharadwaj submits that there are similar writ petitions are pending before this court, which are fixed on 11/6/2025. Mr. P. Sharma, Learned Standing Counsel for the Fisheries Department, is present and has agreed and has admitted said position. In view of the above, NOM return of NOM 6/11/6, since Mr. Sharma has appeared and accepted notice for respond numbers. Who are the respondents? Mr. H. Chakravarti, Learned G. Assam for respond number 1. Mr. Sharma, Learned Standing Counsel, Fisheries Department, Assam, for respond numbers 4. So who is for 2? Mr. H. Alia, Learned SC Finance for respond number 2. Cooperation,
Mr. V. Raj.
Mr. V. Rajkua, Learned SC Cooperation Department, Assam, for respond number 3, 5, 3 and 5. And Mr. P. Sharma, Learned Standing Counsel for Fisheries
4,
Department,
4, 6, 7, 8.
for respond numbers 4, 6, 7 and 8.
For 9
No
and
formal
10.
notice is required to be sent to the said respondents. Extra copies of the writ petition be furnished to the learned departmental counsel so as to enable them to obtain instruction. The question of issuance of notice upon the respond numbers 9 and 10. No, you write like this. Notice upon respond numbers 9 and 10 is kept in abeyance for now and shall be considered at an appropriate stage. Office to list this matter again on 11/6/2025 along with the connected writ petitions. Same order in
Same sequence.
Yes, ma'am.
item 10 also.
Same part, similar.
Same part,
sequence,
similar part,
similar
same
part. Yes.
Highly obliged, Lord.
Please, Your Lordship. This matter pertains to compassionate appointment, my lord. The DLC Dhemaji has forwarded the name of the petitioner on, my lord, 17/12/2022, my lord. Thereafter, the SLC has not acted upon, my lord. My
But
lord,
have you challenged 18/9/2024?
yes, Your Lordship.
Okay, then we'll dispose it of as per the Mr. M. Sekar for the petitioner, Mr. A. Chakravarti, and G. Assam appearing for the state. It will be the same order with a little motivation. Just check in the synopsis. Dispose it of.
Obliged, Your Lordship.
Yes, Your Lordship. Another part also non-payment of, my lord, death benefit as well as family pension. It is this notice may be issued,
Non-payment of family pension.
my lord.
PNRD? Passed over for the day. Why?
It is, sir. Notice is to go back.
You will issue notice?
Only
Take
issue notice.
steps. You are representing whom?
PNRD.
Acha, I'll record his name.
S. Dot.
Heard Mr. K. R. Patgiri, Learned Counsel for the petitioner, peruse the averments made in the writ petition. The matter pertains to grievance expressed by the petitioner on account of non-payment of family pension. Full stop. Mr. S. Dattal and his standing counsel for the PNRD department prays for some time to obtain instruction in the matter. NOM 6 weeks since Mr. T.C. Chutia, Learned Additional Senior Government Advocate Assam, has
2 and
appeared and
5.
accepted notice for respond number
2 and 5.
2 and
5.
5. Mr. S. Dattal and SC PNRD for respond numbers 1,
3.
4,
3.
1 and 4,
4.
and Mr. A. Solia and SC Finance for respond number 3. Service of notice upon respond numbers 1 to 5 is deemed to be complete in this case. Acha, 3 and 7, huh? 1 to 5 and 7 is deemed to be complete in this case. Extra copies of the writ petition requisited numbers be furnished to the learned departmental counsel so as to enable them to obtain instruction. Petitioner takes steps for service of notice upon respond number 6 by registered post with AD within a week from today.
Obliged.
Yes, who is appearing in this case?
His Lordship,
Yes.
the engaged counsel, Mr. M.A. Hussain, he suddenly met with an accident and hurt his back. Therefore, you may fix any other date, Your Honor.
Next week?
Okay.
On the prayer of petitioners council, this matter stands passed over for the day. List again for motion in the next week.
Obliged.
Public fund.
Yes.
Yeah, it is lordship.
My lord, after passing the order by SSFC, that is security, Hamari Security Force, my lord, I filed an appeal to the DG, Director General, my lord, which was not disposed of till today, my lord.
Your client was dismissed from service.
Yes, my lord,
Hmm.
more than 1 year.
And what has happened to the appeal?
My lord, the SSFC, my lord, was not constituted as per section 70 of the BSF Act, my lord, section 70, my lord. And
No, I am asking you, your client has preferred a statutory appeal.
yes, my lord.
What has happened to that?
My lord, no reply has been.
What has happened to his appeal?
Lordship, we don't have the instruction. We have the obtain instruction in this regard, Lordship.
Then let her find out what has happened to the appeal. You wait for 10 days, then we'll pass an order here. Right? Yes. Heard Mr. Your name, please?
Yes, Islam, my lord.
As Islam Learning Council for the petitioner perused the averments made in the writ petition. It appears that by the impugned order dated 12/1/2024, the writ petitioner who was serving under the Border Security Force (BSF) as he was serving as a CTGD, was dismissed from service. The statutory appeal preferred by the petitioner against the order of dismissal from service. The order, the statutory appeal so-and-so against the order of dismissal from service is pending disposal till today. Aggrieved thereby, the petitioner has approached this court by filing the instant writ petition. Mr. S.K. Medhil and his CGC prays for 10 days time to obtain instruction and appraise this court as to the status of the statutory appeal preferred by the petitioner. Prayer allowed. 2 extra copies of writ petition be furnished to Mr. Medhi during the course of the day. Let this writ petition be listed for motion again on 23rd of June 2025 as a fixed date.
Obliged.
May I please ask?
Yes.
There is a BSF constable, my lord, BSF trial, my lord, punished him, my lord, and dismissed from service, my lord. Thereafter, he made a statutory appeal, my lord, that has been rejected, my lord. So challenging this, my lord, impugned orders for this petition, my lord.
We have to issue notice in this case then.
My lord. And
Notice.
notice may go for also, my lord, bail, my lord. I have prayed for a bail and suspend the, my lord, sentence, my lord, as an interim, my lord.
All right. Heard Mr. M. Saranyan and a counsel appearing for the writ petitioner, peruse the averments made in the writ petition. The writ petitioner herein was placed under suspension by the order dated 11/10/2021 while serving as a constable GD under the BSF. Subsequently, departmental proceeding. Subsequently, a staff court of inquiry was initiated against him and whereby the petitioner was found guilty and accordingly was sentenced to imprisonment for 4 years and was also dismissed from service. Full stop. The statutory appeal preferred by the petitioner against the order dated 29/7/2023 imposing the punishment on the petitioner was also rejected by the authorities. Aggrieved thereby, the instant writ petition has been filed. Full stop. Mr. Saranya, Learned Counsel for the petitioner, has prayed for an interim order suspending the sentence of the petitioner by contending that his client is presently in custody.
My lord, in the jail custody last 1 year, 4
In
months.
jail custody since last 1 year.
4 months.
1 year, 4 months.
1 month.
Right. Mr. CKS Borol and his CGC on the other hand has prayed for some time to obtain instruction in the matter. NOM, we'll give a fixed date.
Lordship.
When? We can do two things, either on the sentence suspension, one returnable date, or on the
Fine.
main petition. On the interim prayer, we'll make it short, 2
Fine.
weeks.
That's all,
Alright.
Lordship.
Returnable in 6 weeks, since Mr. CKS Borwal and CGC has appeared and accepted notice on behalf of all the respondents. No formal notice is required to be sent in this case. Extra copies of the writ petition requisite in numbers be furnished to the learned CGC so as to enable him to obtain instruction. Hard on the prayer of interim relief, since the petitioner is seeking an interim order suspending his jail sentence. This matter be fixed again on 25th of June 2025 as a fixed item for consideration of the interim prayer. The learned CGC may come prepared accordingly with requisite instruction.
Smile. I love you.
Who is appearing?
Lordship, House Rent Allowance.
So the council is not there. We'll pass over for one pass over. Yes. Pass over.
Please, your Lordship. Lordship, this matter related compassionate appointment, Lordship. ELC Lordship forwarded the name of the petitioner to the SLC Lordship on 18/9/2025 has been challenged.
So have you challenged the order?
Yes,
Lordship, he has not, Lordship, he has challenged the impugn order 18/2/22, Lordship, where DLC has rejected the claim, Lordship. In this case, Lordship, issue notice, Lordship.
OM has not been challenged.
OM challenged, Lordship,
OM
as
challenged.
well as 18/2/22 also challenged, Lordship.
Case 35.
DLC has rejected his.
Rejected, Lordship. He has challenged that
DLC
order. also.
Lordship wrongly forwarded to the SLC Lordship.
It's been rejected.
Let
Lordship.
him obtain instruction
Lordship.
then. Heard Mr.
Be sorry.
B. Shaurya, learned counsel appearing for the writ petitioner, petitions the amendments made in the writ petition. The petitioner is aggrieved by the order dated inter alia. The petitioner is inter alia aggrieved by the order dated 18/2/2022, by means of which the DLC Darang had rejected his
Lordship,
prayer.
Lordship, as per the annexure, it is
Case
stated.
30,
that
30 Lordship.
the 34 Lordship
Minus
relevant.
Lordship in
portions.
case 30.
DLC Darang had page 30.
30 Lordship. Minus Lordship.
But this is 21/2. Where is 18/2?
18 to, yes, Lordship, in
18 to page 33, Lordship.
In minus Lordship, 18 to 2022 Lordship. In extra 5 Lordship.
No, things are not very clear.
Not clear, Lordship. In the relevant prayers, prayer 34, Lordship. The
Where is
proposal,
the information about the petitioner? Which page?
page 33, Lordship. His name is number 2, Lord, serial number 2, Lordship. Jyotisman Kolita, Lordship.
Yes, Lordship.
And relevant para is page 34, Lordship. The proposal approved by the DLC meeting today is on submitted to the higher authority by the head office within 2 days. Receipt of the minutes of the report in compliance as regards to the
So there is
rejected.
an order of this court to consider his
Yes.
case.
Lordship.
The matter went to SLC.
SLC.
Then what happened?
Not clearly to the SLC, Lordship. This again forwarded to the DLP, Lordship.
They forwarded to the
Yeah,
Right,
SLC.
you write so and so, so and so. The petitioner is aggrieved due to non-consideration of his case
Lordship.
for appointment on compassionate ground. Mr. A. Chakravarti, learned government advocate, Assam, pays for some time to obtain instruction in the matter. NOM 4 weeks. Since Mr. Chakravarti has appeared in accepted
2,
notice
3, 4, and 6, Lordship.
as per numbers
2, 3, 4, and 6, Lordship.
2, 3, 4, and 6. Mr. A. Fukan, learned counsel for the GAD department. On behalf of respondent number 1, take it 2, 3, 4, and 6, and Mr. A. Chalia. Learned standing counsel finance department Assam for respondent number 5. Service of notice deemed to be complete in this case. Extra copies of the writ petition requisited numbers be furnished to the learned department counsel so as to enable them to obtain instruction.
Obliged. No, I'm challenging the order dated by 21/6/2024, and page 127, 18/12/24, whereby I have been ordered with punishment of 4 annual increment with cumulative effect, my lord.
That's a major punishment.
Yes, my lord.
What is the date of the orders?
The 109, my lord, 21/6/24, my lord. So admittedly, there is a delay, my lord. Our delay is been caused, my lord, as because in the order, my lord, this reflects, my lord, the default.
No, that's okay. This delay is nothing. You obtain instruction when Mr. S. Portagola and counsel for the petitioner peruse the averments made in the writ petition being aggrieved by the order dated 21/6/2024 issued by the disciplinary authority imposing the major penalty of stoppage of 4 annual increments with cumulative effect upon the upon the petitioner. The instant writ petition has been filed, inter alia alleging procedural irregularity and violation of principles of natural justice in issuing the impugned order. Full stop. Mr. T.C. Chutia, learned additional senior government advocate Assam, appearing for the state, prays for some time to obtain instruction in the matter. NOM 6 weeks since Mr. Chutia has appeared and accepted notice for all the respondents.
All the respondents.
No formal notice, extra copies.
Obliged. It may be tagged with
Sorry?
It may be tagged with WPC number 2436 of 2020, my lord.
On the request to Mr. Botaku, this matter be listed along with WPC number
2436/20.
2436/2020,
Yes, ma'am.
which is stated to be analogous to the present proceeding. Yes. Yes.
The petitioner hearing was working as a Gao Pradhan of the village in Tezpur since 2010. In the month of June, a manipulated and fabricated photo allegedly of the petitioner was circulated in the social media. Thereafter, Lordship may kindly turn to page
In the month of June, which year?
of 24. Thereafter, at page 42, an order was passed by the Deputy Commissioner on receiving complaints from the local committees to inquire into the matter and was directed the circle officer to conduct it within the 7 days. Lordship, thereafter, I was removed from the post of Gao Pradhan, and the circle officer till date has not concluded or conducted any inquiry. 8 months has passed and I am not even receiving any honorarium in this put.
You have been removed
Yes,
without any inquiry.
without any notice, without any inquiry.
Yes, Mr. Datta.
He is not removed, my lord. He is for a temporary suspending him, my lord. Page 44.
No, even if it is temporary, he says you have done it without serving any notice upon him.
I will obtain instruction, my lord.
Lordship, may kindly turn to page 129.
All right, let him obtain instruction.
Yeah,
We'll fix it on motion for motion only. Mr.
H.
H. Agarwal, learned counsel for the petitioner, peruse the averments made in the writ petition. The grievance of the petitioner is that he has been unceremoniously removed from the post of Gao Pradhan of lot number 11, Bamun Suburi, under Bhairav Pad Moja, Tezpur Revenue Circle in the district of Sonatpur, merely because some pictures appeared in the social media in the month of June 2024. Mr. Agarwal submits that although the appointment of the petitioner was temporary in nature, it was temporary?
No, appointment was not temporary.
Not temporary. Submits that the impugned order was issued. Submits that the removal of the petitioner was carried out without serving any notice upon him. Mr. T.C. Chutia, learned additional senior government advocate Assam, and Mr. S. Datta, learned standing counsel for the Revenue Department Assam, have both prayed for 10 days time to seek written instruction appraising the court as regards the veracity of the allegation made in the writ petition. Prayer allowed. Just this matter for motion again after 10 days as a fixed item. One extra copy each be furnished to Mr. Chutia and Mr. Datta during the course of the day.
Quickly open.
One extra copy of each of the writ petition. Yes, what is this matter?
Your lordship, to understand this matter, first we will have to understand that
Yes, yes.
even in our Assam police,
Hmm.
that whenever any kind of law and order situation take place, so there is a reserve to help the
No,
main
we'll
ground
understand.
duty
First,
police.
tell me what is the matter about?
This matter is pertaining to an transfer.
Hmm.
The transfer order,
Where is the
is-
transfer order?
it is at page 23, annexure 1, 16/4/2025. So by this transfer order, what
Hmm.
this RPF officials, higher authorities has did is,
Hmm.
they have created a decisive difference between the RPSF and RPF. So RPF are the main ground duty officials, whereas RPSFs are just for the support, like a reserve police. So here what happened is,
Hmm.
on 5/2/23, on the approval of the DG, there was another request was been done to call for the invitations for interzonal transfer, and following which your lordship will find at page 129 at
Yes.
130 annexure 9, all the petitioners
Hmm.
has applied for their interzonal transfers. And again, there what happened here in this transfer order is, the ratio was not equally been distributed. Only just 142 something was allowed
Hmm.
to the RPF officials to have this benefit. Apart from this, the Directive 60, which talks about the RPSFs. So the RPSFs, while availing the benefits of transfer or the other benefits, they have to get themselves convert from RPSF to RPF first. So this is that Directive 60 talks about. Directive 58 revised talks about the tenure, that by 10 years to 15 years, if at a stretch, that any constable rank or any other officials of an RPF has served any area or pertaining to hard zone posting or including the bad climate, they will have the first preference, which has been modified in 58, Directive 58 modified, where it says now 8 years is sufficient. And after that, the standing order, if your lordship may just pursue the standing order once, at page 124.
So your clients are RPF.
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 Or RPF. Now, if your lordship
And
may
what
just
is
see,
what is RPSF? What does it mean?
RPSF, they are also constables, but they are generally been reserved. So main duties are being performed by the RPF to look after all the law and orders and to maintain the Railway Act and the railway rules, everything. In case of that, any further officials or further constables are required, so they may call for the RPS. So then the RPF SF is actually a supporting constables to the RPF. So in page 124, this is the standing order.
Yes.
Here it says 80%, if your lordship may have found, part 5, clause B. 80% of all vacancies for a particular zone shall be filled up in accordance with the seniority of applications for that particular zone to be established after combining the request application received from all zones. For filling up these vacancies, RPSF personnel shall be preferred for the first 50% of the vacancies of a particular zone. However, if the number of the willing RPSF personnel exceeds 50% of the vacancies, the remaining
So
50%.
you are challenging a policy decision.
No, not policy. This transfer, that 16/4/25, this notification we are challenging. Because in this notification, the list which was published by the Deputy Director Establishment, respondent number 3, on approval of this DG, here the ratio has been 76/24%. Means the already
So the ratio is wrong.
ratio is
That's a
completely
policy
wrong.
decision.
So that is why we want an stay.
Difficult. We'll ask them.
Because
We'll give them.
there are other applications also, other RPF, other journals, they have also filed, and this matter is pending on Allahabad, Delhi, Gujarat, Mumbai.
Any order of any court?
So we have not got any order, but we have asked our petitioners to collect the order and to submit so that we can proceed it and bring it on
But
record.
how long will you take to submit it?
2 days will be sufficient.
Then we'll have it on Monday?
Yes.
Also, you also obtained instruction? Yes. As Swati S.B. Borua, Learned Counsel for the petitioners place for time till Monday, that is, give the date, to obtain orders passed in similar matters by other high courts wherein interim relief has been granted to the petitioner. Prayer is allowed. Registry to list this case for motion again on Monday is, what is the date?
9.
9th of June is fine?
Yes, fine.
Right. In the meantime, Ms. B. Sharma and CGC to obtain preliminary instruction responding to the grievance expressed in the writ petition. Can you give her one
Yes,
extra
I will
copy?
give an extra copy by
One
today.
extra. All right.
So there is already an standing order. Everything is there in my favor, and then the ratio is getting wrong.
If there is any order, you give us, then it will
Yes.
be, all right? Yes.
Obliged.
Yes, Mr. Bhuya.
My lord, my colleague friend, my lord, from the health department was about to obtain instruction, my lord.
Hmm.
Perhaps they are not.
No, Mr. Cholia, he was here a little while back.
Health.
What is the matter about?
My lord, matter about is that regarding my degradation, my lord, from my promotional post of senior assistant, my lord, at page 50 is the, my lord, order by which we are agreed. My lord, may be pleased to find the operative part.
Hmm.
Is at page 52, my lord, in view of above. That paragraph is, my lord.
Yes.
Well, I've got the instruction, my lord.
Mm.
As per my instruction, my lord, if the approval is given by the government, so cause will be issued to the petitioner. If at all there is a decision to resolve, opportunity will be
My
given.
lord can close it
So no action without
Without a so
procedure.
without a, not a so cause, but a notice.
Okay. Then we'll close it.
Yes,
Lord can
I've
close
got
I
the
heard Mr. A.R. Bhuya, Learned Counsel for the petitioner. The instant writ petition is directed against the order dated 21/3/2025 issued by the Director of Health Services, Assam. That is the respond number.
Lord, the respondent number, my lord. Respondent 2, my lord.
Respond number 2 herein, proposing to downgrade stroke revert the petitioner back to the post of surveillance worker without serving any prior notice. Full stop. Taking note of the grievance expressed in the writ petition by order dated 28/5/2025, the Learned Standing Council Health Department Assam was granted time to obtain instruction. Full stop. Today, when the matter is called up, Mr. Gogoi, Learned Additional AG, bracket health, bracket close Assam, submits an instruction that no action will be taken against the petitioner in terms of the impugned order dated 21/3/2025 without serving a prior show cause notice upon him. If that be so, the basic grievance of the petitioner expressed in this writ petition appears to have been redressed. Mr. Bhuya, Learned Counsel for the writ petitioner, has also fairly agreed to the same. In view of the above, these writ petitions stands disposed of at the stage of motion hearing by taking note of the submission of Mr. Gogoi that no precipitate action will be initiated in the matter against the petitioner without serving prior show cause notice upon him.
Obliged, my lord. Highly obliged.
May I please, Lordship? My lord, we
Yes.
have challenged the impugned order that Lordship may kindly see page 59.
Yes. Page 59.
2 lines order, my lord.
Yes.
I was the PDB secretary and my appointment date was 23/5/2016. That has been passed. Thereafter, my lord, due to some illegalities committed by SP, my lord, I was again appointed that I have challenged, and this honorable court passed an order in my favor. And since then, that is from 30 11/23, I am the secretary. Now by this order, immediately I have been thrown out without issuing any notice, without serving any show cause notice.
Yes,
I'll obtain instruction, Malad, this is page 60, Lordship LDC. This is approval of the new committee. The new committee of the Durga VDP and Boanga PS has been reorganized.
Yes.
And approved on 30th November 2023 with the following new official by dissolving the old committee. So here the duration is not there, Malad.
The duration is 5 years.
Duration is of 5 years, so here is not mentioned against.
And this is
How
my
long they will
approval
be-
letter.
How long they will be in the secretary?
but there must be some procedure for removal and
Procedure-
replacement. What is that procedure?
No, I don't know, my lord. That's why I will obtain instruction. In VDP secretary.
All right, when do you want it?
Next week, my lord.
Let him have the instruction, we'll pass an order.
My lord,
There may be
but
some-
till then.
No.
You wait for 2 days. What is
Because my
the?
lord, SP has passed the order.
No, you wait. It's a 29-5 order. We'll
Yeah.
have it on Monday.
Monday, my lord.
Till
Monday.
then, I may not be disturbed.
No, nothing. I heard Mr. M. Mandal and
Well,
counsel
this
for the
is-
petitioner peruse the amendments made in the writ petition referring to the impugned order dated 29/5/2025 by means of which the petitioner has been replaced by replaced by the private respondent. His private respondent number
5.
5 as VDP secretary of Durgamari VDP under Bongaigaon PS. The instant writ petition has been filed inter alia contending that the impugned order has been issued dehotes the law and in utter violation of the principles of natural justice. Responding to the above, Mr. T.C. Chutia, learned additional senior government advocate Assam, prays for some time to obtain preliminary instruction responding to the allegations made in the writ petition. Prayer allowed. Office to list this matter again on 13th of June 2025 for motion as a fixed item. 2 extra copies of the writ petition be furnished to Mr. Chutia. Having regard to the overall facts and circumstances of the case, this court is of the opinion that a prima facie case pertaining to illegal removal of the petitioner without following the due process of law has been made out. As such, it is hereby ordered that status quo as regards the present position of VDP be maintained till the VDP secretary be maintained till the next day.
Hello, obliged.
Status quo as on today, my lord.
Yes.
Time being motion matter item 12.
My lord, may I adjourn this matter for today, lordship. If it's
On the
not-
prayer of learned counsel for the petitioner, this matter stands passed over for the day. Ms. B. Sharma, learned CGC is present for the respondents.
For order item 17.
May it please your lordship. Lordship should kindly come to the order under review, my lord. That is at page number 56. Please come to page 66.
Yes.
Paragraph 12 onwards. Responding to the plea raised in this writ petition, D. Gogoi, learned standing counsel, Forest Department, has submitted in his usual fairness that as per the departmental record, the appointment of private respondents as forest ranger does not appear to be based on any valid selection process conducted by the APSC. And to that extent, he is not disputing the claim of the writ petitioner that they having been selected by the APSC in a valid selection process and their names having featured in this list of selected candidates for the forest rangers published by the APSC, private respondents who were recruited subsequently and were below the petitioner in order of merit ought not to have been treated as senior to the petitioner in service, nor could they have been promoted to the higher post ahead of the petitioners.
Gogoi, however, submits that although the department is accepting that there is no anomaly in the process, yet considering the long years of service rendered by the private respondent and in the interest of proper functioning of the department, this court may not interfere with the appointment and promotion given to the private respondent. Learned Departmental Counsel, Mr. Gogoi has assured this court on instruction obtained by him that if a direction is issued by this court, the seniority position of the writ petitioner would be restored in terms of OM dated 11/2/2020 as reiterated by notification dated 2012-25 and consequential service benefit would also be given to them. My lord, basically this para, my lord, it appears that the government advocate agreed that we were not selected by any valid selection process. This is one basis. And secondly, my lord, the learned government council's concession was also recorded that the seniority of the would be resorted in terms of OM dated 11/2/2020. 11/2/2020 was no longer holding the field on this day. It was by another order, my lord, that was superseded. That's why, my lord, 4292 was closed by your lordships. So an error apparent on the face of the records has crept in. Now please come to the next para, my lord, para 13. And Gautam Learned Counsel appearing for the private respondent has submitted that if no adverse order is passed against his client in this batch of writ petition, then he would have no objection to the submission made by the Learned Departmental Counsel. My lord, we have made a categorical averment in the petition, my lord. No such concession was given on our part. Now please come to the select list, which is at page number 29. How government advocate could make that statement that we were not selected? Please come to page 29, my lord.
Page 29.
29.
Yes.
Serial number 2, Kukhal Kumar Deka is the petitioner, and serial number 6, Sahadat Ali is the petitioner. Then serial number 11, Ashok Kumar Dev Chaudhary is the review petitioner number 2. Serial number 14, Mustafa Ali Ahmed is review petitioner number 1. So to say that we are not selected, that we are not, in a validly select process, that's not correct. Then my lord will kindly come to please come to my lord that we have filed an additional affidavit on document was
Just a minute. How many review petitioners are there?
2, my lord.
And their names are there in this page 29.
Yes.
Serial number?
11 and 14. So all that I am saying is, my lord, this writ petition needs to be reheard. I'm not saying that their petition should be dismissed today. The matter needs to be heard. Prima facie, my lord, there is an error apparent on the face of the record. That is my only case. And secondly, my lord, if your lordship would kindly come to page number 73, part of the additional affidavit. That is the final sheet prepared by the Training Institute, my lord. Page 73. Serial number 3, Ashok Kumar Dev Chaudhary secured 69.12% mark. And serial number 9, that is review petitioner number 2, secured 63.06 marks. Then my lord will kindly come to next page, page 74. Sahadat Ali on top, serial number 78, I think. He got 59. Then serial number 36, Kukhal Kumar Deka, he secured 52. Serial number 36 and my lord serial number 18. These are the two respondents in the review petition.
So, Mr.
And one more thing, my
Gogoi,
lord. One more thing, please come to your lordship's order once again. Please come to page number 67, my lord. Last four sentence of para 12.
Yes.
Mr. Gogoi has assured this court on instruction obtained by him that if a direction is issued by this court, the seniority position of the writ petitioner would be restored in terms of OM dated 11/2/22. This was no longer in fill, as reiterated by notification dated 2012-2005. Now this 2012-2005 we have annexed, my lord, at page number 36. If you fail, then you don't get seniority, even if APSC list is taken note of. Page 36. Page 36, my lord. This is 2012. My lord, in fact, we file a written submission. We have annexed all these things. Last para. Now, therefore, in supersession of earlier order, the governor of Assam is pleased to decide that inter-C seniority of forest rangers appointed as per merit list of APSC shall be fixed in order of preference of the select list of APSC with effect from 1/4/86. Now, this is important. Subject to the condition that officer trainee must pass the training during the stipulated period, failing which he shall lose his seniority.
You are reading from page
36, my lord. This is the OM which my learned friend made a submission and which your lordships recorded that the seniority will be restored on the basis of this document. How can it be restored? You have failed in your training. Even if, my lord, the issue before the Honorable Court was, my lord, whether the seniority can be fixed based on APSC merit list, order of preference or order of preference in the training.
So his clients were higher in the
Higher in the APSC list, but failed in the training. And we are lower in the APSC training list, but we came out successful, securing higher marks. And rule also says those who secure higher marks, they alone will be appointed.
That rule is
Yes. Well, in the written argument, copy, yes, sir. Good. Huh? No. On last occasion,
yes, it is there. Written argument is there.
Only 2 pages, my lord, a part of that manual. এখন কিতাপখন নেই This is the book, my lord. No, এখন এটা পাত আছিল নহয়
So which is the rule which says the seniority will be fixed as per the merit ranking in the training course?
This one, my lord. One who get higher percentage will be made ranger, and those who get lesser mark, they will be made deputy ranger. And there is a Supreme Court judgment also, my lord. My lord, I submitted a written argument before lordships.
Yes.
If it is not there, I can handle.
No, it is there. It is there. It is there.
Please come to me, lord. Page number 6. Submission number 2. For that, respondents number 6 and 7 are stopped from claiming seniority based on the merit position of APST list after having participated in the selection process in view of the clear stipulation to the contrary contained in the advertisement, condition in the order of appointment, deputing for training, final order of merit published by the concerned forest ranger training, and the provisions contained in the Assam Forest Manual volume 2, page 12 and 13. Chapter 4 thereof with the caption appointment provides that conservator may appoint the following to the class of rangers. Candidates who have obtained honors or higher standard certificate after 2 years training in the forest college training. Therefore, the condition in the advertisement and appointment or notice above are consistent with the provisions of Assam Forest Manual so and so. The above issue also stands concluded by the apex court in so and so. The apex court referring to the Gujarat rules which fell for consideration observed that seniority of rangers will be governed by result in the final examination of the college irrespective of their joining in the service, and on successful completion of the training, the candidates should be confirmed as ranger if they pass with higher standard certificate. For that, it is an admitted position that as on the date there are no recruitment rules for recruitment to the cadre of rangers. In the absence of any rule, Assam Forest Manual Volume 2 is being followed, as can be seen from the communication dated so and so. There is no dispute that petitioners have successfully completed their training from the concerned college at Jalukbari, securing higher standard certificate that is 70%, 67%, 65% and 63% respectively, as against 59.48 and 52.46 secured by the private respondent. As is evident from letter dated 1/12/2005 of PCCF, Assam, the practice of conferring seniority to forest rangers based on merit list of forest rangers is being followed in the forest department ever since the same was prescribed in the manual. It is respectfully submitted that the past practice of conferring seniority to the recruits based on the merit list of college is consistent with the provisions of the Assam Forest Manual as noticed above. The Honorable Apex Court in Suresh Nathan had so and so observed past practice which is based on a possible construction of the rule should be preferred. In any case, as pointed out herein above, right from the advertisement and all subsequent communication, including orders deputing the candidates to training course and order of appointment clearly indicates that an order of preference indicated in the select list published by APSC are not decisive inasmuch as it is the merit list prepared by the Forest Rangers College which will be determine the interests. But this was the issue, my lord.
Is there any appeal pending against these judgments? No appeal.
No. And in fact, Lordship has already reviewed in one case, my lord, at the instance of one Dibakar Bora, Lordship has already reviewed the order.
No, Dibakar Das was something different.
Dibakar Das.
Dibakar was something different, man.
Actually, is the order there?
Yes, yes.
The original, which allows me, when this matter was taken up, my lord, so the first basic question is that who is senior, but one thing, Lordship went beyond that, and the mode of entry was a sale, my lords, because admittedly, my lord, the review petition, the writ petition therein, my lords, was not within the original 18 applicants, my lords. The APC advertisement spoke of 18. Then there was a question put to me, my lords, that shows some materials that they are the original 18.
Well, I don't know. My learned friend, he is representing the government. Government has all along supported us. How all of a sudden, my lord, they are taking a conclusion. Very surprising things are happening, my lord.
No, my lords, it's not.
No, the government, it's the, where in the affidavit you have opposed our prayer. They have supported our case.
No, then my lords.
Then if once there is an affidavit, you are not supposed to take a
Lordship wanted to pull everybody down. I just showed a judgment of Vivek Kaist. That was some judicial officers, my lords. They were appointed, found wrong, but that finds reflection in Lordship's observation that due to long service period, it might not disturb. So the basic question which came to this before the court, how they entered the service, because Lordship says admittedly they were not within the 18. It was not my case. Not I'm neither supporting and I'm negating anything, my lords. When this question was put to me, I had no answer how they entered those beyond the original application, my lords. That's all. That was the basis of this judgment, my lords. And what I have stated, I might have stated that paragraph my learned seniors pointing out, that doesn't call for any review, my lord. What calls for review, my lord? What is the judicial finding? Because those are my statements. Those are my only submissions. Submission did not need any review, my lords, because I will stand by those statements. What needs review, my lords? What is the effect of this judgment, my lords? Cascading effect of the judgment, my lords. What is the rationale, my lords?
What is the effect of the judgment?
My lord, effect of the judgment is, my lords, now since long time has passed, there's a gradation list, my lords. One has stolen march about one fellow, my lords. So it is the difficulty they are finding now. The department is finding a difficulty now to adjust one another, my lords. Because Ashok Dev Chaudhary, the review petition has already been promoted. Pursuant to court's direction, Kukhal Court Deka, the respondent has also been promoted. But now if we recast if we recast now, my lords, there will be some given an addition and subtraction, my lords. That is the issue. And it's not a question of who government is supporting what. No, my lord. I have to go by
No,
records.
government support, forget it. We'll go by the rule.
Records. The basic question, lordship will see annexure A, my lords. Annexure A, the original under applications are called for original 18, my lords. And the list, which is shown by my learned senior, my lord, it goes beyond 18, my lords. At page 29.
Annexure?
Annexure A, page 17, my lords. Lordship will see applications for 18 stipendary studentship, my lords. Applications were called for 18. Then the question, lordship, the page 29, then, my lords. 29 is beyond 18. And lordship will come to annexure C, 30, annexure C, 31.
Initially, the applications were invited for 18 stipendary students.
Yes.
Now, in that APSC list, does Mr. Chaudhary's client come within the 18?
No.
Why not?
Annexure C, my lords. Annexure C, page 31.
Page 31.
31, my lords. This is the question put to me, my lords, whether they are in this list or not. The basis of that judgment is this list, my lord.
So, in this 18, the two review petitioners are not there.
No.
Why?
Well, they didn't apply, my lords. But they didn't.
No,
They had applied, but they
but
were
you
not
be very
selected. They were
careful
not
in
selected,
what
my
you-
lords. They were not selected. It seems from this. On that very day of this judgment, I had no materials to show that they had also, they were there, my lords.
Oh, there are two review petitioners. One is Mustafa Ali
Mustafa,
Ahmed
no, my lord.
and another is Ashok Dev Chaudhary.
Yes.
Now, this 28 July 1989,
Nobody, these two petitions, this not review petitions, not there, my lords.
they are not a part of this 18.
No, my lords.
Why?
My lords. My
They
lord.
were not selected by
No,
the
my lords.
APSC.
No.
Is that so, Mr. Chaudhary? They are not part of this 18.
My learned friend is making submission with lot of conviction.
No, that's right.
Actually, what happened, Milord, because of the reservation, Milord, in the 18, we did not come in. Otherwise, our name appears in the select list at 11 and 14. Because of, Milord, reservation, Milord, our name did not. We are general category.
So correct. So therefore, in the 18 advertisement was for 18 stipendary posts.
Yes.
When the final list was
No, Milord,
prepared.
your lordships proceeded on the basis that we were not even selected. That's what I have shown from the order, impute order under review. We were selected. It's not that, because he made a submission which was recorded, which is the basis of the order, that I was not selected. That's not correct. I'm selected. I'm a serial number 11. One is at 11, one is at 18. But
that's
while making appointment, we could not find a place because of operation of the roster. But my lord, whose case is it? Petitioners have filed petition since 1993. In which petition the petitioners have?
I'm trying to understand.
Yes.
See, because these are very heart-burning issues.
No, my lord, what I'm
If
saying
there is a real issue, then I am open to reviewing.
No, my lord, my humble submission is very simple. There are two basic premises on which the judgment has been rendered. One basic premise is that I was not even selected. That is not correct. If that is
So according to you, I'm
Yes.
trying to understand.
yes
Regardless of whether you come in the final list of 18
or not,
you are selected.
I'm selected.
So that it is for the court to accept or not.
No,
Because-
the select list I have produced.
No, but selectees will be the people who come in within the 18. Don't you agree with that?
No, my lord. No. Now please come to the order, my lord.
Yes.
Your lordship's order,
Page.
para 12.
No, what you're saying, you may be right.
Yes.
I'm only on the question whether these are matters of review or not, only on that.
No, it's a question of review
Hmm.
because an error apparent on the face of the records has crept in. Because lordships proceeded on the basis that we are not even selected.
No, but if you are selected, then why were you not appointed in the
No,
first
I
class?
was not appointed because of the roster of operation of roster, but subsequently I was appointed. My lord, is it so abhorrent a concept in service law that merely because the specified posts were 18, therefore more
All
posts
right,
cannot
so
be appointed?
I have understood your case.
Yes.
If I have understood it correctly, what you are saying is that, all right, initially 18, I participated, APSC published a list, but finally by adjusting the reservation.
Because the select list was still alive.
Yes, only 18 people could have been shortlisted.
Yes,
And for XYZ reason, our names did not feature in.
initially, yes.
Then we went to the government and make a representation that we have been.
There are
trying hard.
vacancies in which you can be
So why don't
accommodated. Select list is valid.
Why don't you appoint us?
Yes.
To that, till that point of time, you admit that these people are higher than you if only a PSC list is taken. If only this select list is taken,
Yes.
they are higher than you.
But then will not, yes.
I'm coming to it. I'm trying to understand the problem because
Correct,
these
correct.
are very sticky issues.
Yes,
If your clients have a case of review, then they will certainly
yes,
get it.
yes.
And otherwise, obviously. So next year question is, then we are all subjected to training. And in the training process, we were not only higher than them, but they didn't even succeed.
Yes.
But all of us were appointed as rangers. But according to you, they should have been appointed as deputy rangers and not rangers.
Yes.
And secondly, by virtue of the rules, our seniority ranking will be only in terms of the merit position in the training and not otherwise.
Yes.
The court in the impugned judgment proceeded in this line, which may or may not be correct.
Correct.
And if it is not correct, I would recommend it should be tested.
Yes.
Only question is whether it is a matter to be interfered in a review petition.
Yes.
That is the only question.
Yes.
The court took a view that you may have come in for this reason, that reason, whatever. But since the process was for 18 posts, once the list of 18 is finalized, rest of the people, even if they have come in, according to the court, the government may have reasons to do it. Nobody is questioning your appointment.
Their wisdom, yes.
That we are not getting into it. But the question is, you have come in through a process which was not the process initially envisaged by the advertisement. So therefore, having come in that manner, can you jump and override
Yes.
the other?
If your lordship would have taken that view in the order under review, then your lordship is not a case for review. But lordship has not taken that view. If your lordship would have taken that view, then it would not have been a case for review. But lordship has not taken that. The reason is very simple. Please come to page 67. Now, end of the day, my lord, his submission was taken note of. Then only lordship decided.
No, that's right.
Yes.
Submission
Now,
you-
please come to page 67.
So which is the finding of the court which requires review? That's
Yes.
what I'm asking.
After para 14.
Yes.
After recording para 12 and 13, para 14. After hearing the argument advanced by the learned counsel for the parties, and on a careful scrutiny of the materials on record, this court is of the view that writ petitioners herein were duly selected by APSC for recruitment in the post of forest rangers and were subjected to training. As per the merit position in the APSC list, the writ petitioners undoubtedly ranked higher than the private respondent. This is wrong.
Why? Where is the merit list where your clients rank higher?
Yes,
Where
page
is it?
29. Page 29. Ashok Kumar Devsuri at serial 14 Millard, Mustafa is at 14.
No, I understand. Okay, I get your point.
Yes.
We'll deal with it, but difficult to accept. You are saying that forget page 31. 21 is only that matters.
Yeah, in fact, Lordship took note of that. Merit list what? Merit list is the APSC merit list. And end of the day, my lord, what was the issue that was before the Honorable Court? whether seniority would be determined in accordance.
That I agree. That is an issue.
Ah.
That is an issue
And
which.
secondly, my lord, please come to page 67 because this has also seriously, my lord, dented the process. A line about 1, 2, 3, 4, 5 from bottom at page 67 of para 12. Learned Departmental Counsel Mr. Gogoi has assured this court on instruction obtained by him that if a direction is issued by this court, the seniority position of the writ petition would be restored in terms of OM dated 11/2/2020. Well, not OM dated 11/2/2020, we put to challenge in 4292 because
That was
they
withdrawn and
superseded that's why Lordship closed that petition.
Correct.
This one, and secondly, my lord, as reiterated by notification dated 2012-2005. 2012-2005 says two things. Number one, seniority will be determined as per APSC, but that is with a rider. Rider is he must pass. He failed, they failed. So how my learned friend, based on instruction, could have given this, and these were taken note of by your lordships. Therefore, I am saying, my lord, it's a case which should be re-heard. I am not saying, my lord, that their writ petitions should be dismissed today. It should be it should be restored to the file and matter should be reheard.
So, Mr. Gogoi, OM dated 11/2/2020 has been withdrawn.
Well.
And OM dated 2012-2025.
20 is in abeyance, not withdrawn.
Whatever it is. That's why my writ petition was withdrawn.
No, that's just a minute. So,
It is
what has happened to 11/2/2020?
11 to 2020.
11/2/2020 was overridden by my lord.
No.
11/7/2020. That's why, my lord, 4292 was closed by your lordships. Yes.
And where is that 11/7/2020? Is it in the record?
1 second, my lord. Order to cure. Order to children, no? Jitu Amar court Harry court. Yes. Lordship will have a look at this order when 42920 was closed by your lordships because of that.
I go to 13 to 24. 429. 4942. 49421.
429.
49.
নহয়, এক মিনিট ৰবা। 429. আমি কোনটো কৰিছিলো 4942 না
4942.
সরি একটু ক্লোজ রাইট গোটেই কিটা কিবা এক এক নম্বৰ আছে দেখিছানে কনফিউজ হৈ যায় নহয় তুমি দেখিছা নাই এইটো 4942 এইটো 4294
What has happened to the draft service rule? You are creating all this trouble. So many years you don't have a draft service rule.
It is with the APSC.
Huh?
We have sent it to APSC matters. We have finalized it. We have sent it to APSC for vetting.
So at the moment, no further action. You maintain status quo till the draft rule comes.
My lords.
We are not going to pass any orders. What is this? So many years since when? I don't know.
There was another litigation matter, the forest rangers matters. They approached us, then there was a direction that we can go by the executive instructions. We are doing that matters. And now it's a APSC, APSC in the session on matter matters, draft rules. It's lordship is correct. It's taking too long, my lords.
There has to be some limit to all these things.
My lords. It's something I cannot say.
My lord, we kindly appreciate one thing. It is only on the strength of 11 to 20 that the seniority can be fixed in the favor of the other side.
No, you can go ahead with promotion, but don't pass any final order on seniority.
My lords.
Seniority in the rank of SCF. Let the promotions happen. But
petition number 2.
I even recall, my lord, this argument was made. Then there was a judgment shown by my senior man Bharat Singh. And then they said, if this case is not clear, how can you entertain? Then lordship said, no, the shoes have started pinching now. I can enter. This question can be entered into that. How you entered into service, my lords?
No, but that is not the basis.
No. That because everything is being blamed on me, my lord. It's not that, my lord. When on that particular day, then I had no question, I had no answer that how they entered the service, my lords. That was the basis of all the judgment, my lord. Because original 18, that question was put forth to me, whether they are the original 18. I said, no, I have no materials to show. That is also one of the basis of
They are
this
not the
judgment.
original 18. They are
That
not
was
the
the-
original. As per the selection process, they are below. On that ground, I am rejecting Mr. Chaudhary's argument.
Yes, ma'am.
They cannot come above the people whose name are in the list in page 31.
In
But
fact,
the
Lordship-
question is, later on, how do you fix the seniority?
My lord.
No, my lord, end of the
In
day,
fact, if
if
lordship-
your lordship decides that it is as per APSC select list, then lordship you taken is all right. But if it is on the based on the my lord position in the training, that's the dispute. That dispute is yet to be decided.
That's correct. And
But Lordship had spoken in Lordship's
just a
mind
minute.
in page 68.
This,
my lord.
this rule that you are referring
Yes,
to,
that is the only. My lord, let me make one submission. My learned friend can also verify. Ever since, my lord, this 42 thing executive instruction came into force, till that is being followed. My lord, in the advertisement it was made known, in their appointment order it is made known, in the posting order.
so therefore, are you having objection to their promotion?
No.
The seniority, you await the finalization of the rules.
Yes.
Service rules. Correct. That's the order will pass here. Clarifying. We'll close the review petition.
Yes.
So that might creep up, subject to.
Ah.
I'm making the submission with utmost humility, my lord. Now, if a service rule is to come into force from tomorrow, a service rule cannot account for outside appointees.
No, we are not going into.
No, now exactly what has happened, my lord. There's just two documents have not been annexed, which are part of the writ petition. When the initial 18 list was published, the writ petitioners, along with the other 16, my lord, they are deputed to undergo in-service training in various forest ranges. We were born in the cadre, my lord, before the review petitioners were even born in the cadre.
Then we'll allow the review petition. This has then writ petition has to be reheard. If
My
your
lord,
submission is to be taken
your
note of.
lordship had taken note of the entire set of facts, and your lordship had directed the matter to be as per the APSC merit list.
First of all, this is not an argument you can make in a review
Absolutely,
petition.
in fact,
Your only argument should be there is no ground of review.
There's no ground of review.
But because of your argument, I have to now rehear the writ
In fact,
petition.
my lord, those grounds were taken and considered by this honorable court. That is my only submission. That the order is not wrong, my lord. It doesn't call for review.
No, but let the service rule be finalized. Till then, there will be no
But at least we
determination of inter-se seniority of
In the
officers
promoted cadre.
and in the promoting cadres. Because otherwise it will create more confusion.
Since this, we will confine only to this batchman.
Only to prove.
No, but how are you determining the?
Because what had happened, this we had messed up, this batch, my lord. But other batches are running smoothly, my lord, and we are going by executive instruction. Nobody has any quarrel, my lord. Only this batch is a specific.
Now, what is
unique
the
quarrel.
executive instruction? Executive instruction is seniority in the trainee.
And also, my lord, by the advertisement. Because it's a tried law, my lord, recruitment and posting is two different.
Mr. Chaudhary, I am asking you one thing. See, let us not lose our objectivity. You are obviously canvassing a point for you. What the grounds you are taking is why don't you prefer an appeal against this order?
My lord, I think I'll do that now. Now, my lord, all that we are saying is there was no adjudication on merits. There was some concession recorded based on which lordship passed the order. And the concession from my junior side was also, we have stated, my lord, no such was made. And we have checked up from the video recording also. It was not made. My lord, had there been an adjudication on merit, then I would have definitely gone to writ appellate court. Because there is an error apparent on the face of the account. Then, my lord,
There was no, how can I write
we'll
this?
withdraw this review petition, we'll prefer an appeal. That will be best. Lordship will kindly, remove that concession from their side, Miller. We'll file an appeal. Actually, I filed an appeal only for this reason. Sorry, I did not file an appeal because, Miller, apparently there was a concession part, which we never gave. And we have made in the review petition, Miller, we have made their submission also. Kindly have a look, Miller.
Yes.
If a lordship should kindly come to page 11, capital B.
Page 11, capital B.
Yes. That in paragraph 13 of the judgment and order, this honorable court was pleased to hold that on the basis of submission made by the counsel for the review petitioner, that in case no adverse orders are passed against the review petitioner, then he would have no objection to the submission made by the learned departmental counsel. This particular concession was neither pleaded in the written submission nor in the oral argument advanced by the counsel for the review petition. The Lordship will take care of this, we will withdraw this review. Tomorrow if we go to appeal, court will say you have already conceded. This was not done.
No, so even if no adverse order is passed, still there will be objection. Is that the meaning of this?
What we are saying is, Milord.
No, I remember he has clearly made this submission. This is creating embarrassment. He said, I would have nothing to say if it doesn't affect my clients. I remember that.
Yes.
So that is the
This
submission.
client means, Milord, they should not be given seniority.
No, the seniority is not to be given to them or anyone. Seniority is to be determined.
Issue boils down to seniority.
Correct.
Issue boils down to seniority.
Now, Mrs.
And
Chaudhary-
that issue was not even
Mr.
decided.
Chaudhary, now let us come to the brass tacks.
Yes.
If you still insist that there was no such submission made, we'll have it on Monday. I'll retrieve the recording.
Yes.
And then it will take a.
Yes.
Because I
yes.
clearly remember that
Yes, it can
it
be
was
seen,
not
Milord.
on that day.
We have also checked, Milord.
It was not on that day, but on a previous date.
The Lordship can check it
Then
any day.
we'll call on the.
Previous day, though, it was not there. I was present. On that day, I was not present only.
He only,
And
I
I see,
remember.
Milord, on the face of the written argument, where is the scope? We have submitted a written argument.
No, he said that I have nothing to say if the order does not affect my client.
Yes, the order will not affect his client if no seniority is given to them. That's the only issue.
So he never considered to seniority to them. That was his submission.
No, Lordship can check the video recording. There's absolutely no problem. We have checked it. Thereafter, we made this submission statement.
Do you have the dates?
Yes, or the date of the order.
Yes. No, it was a CAB order.
28/3/24.
Just a minute. Let me see the writ petition. When was it heard?
28/3/24 was the date of hearing.
Let us see. Writ petition. No, Mr. Chaudhary, two things can be done. Let's not take it beyond a point. If your concern is that this will come in the way of preferring an appeal, that provision can be made. You will have a wider canvas.
Yes.
Your point may be genuine. I'm not saying. You may have a point.
Review has its own limitations. That I
But
appreciate.
if you insist that he did not make this submission, then we'll.
All that I want is, Milord, that observation should not be there. I leave it to your Lordships to take care of that.
Because your clients have a right to have this answered. That,
I know, Milord,
right.
appeal, I can argue everything.
That's why. In a review petition, how far can you?
Circumscribed, that I appreciate.
So is it okay? Are you agreeable
Yes,
to
yes.
that order?
As long as Lordship takes care of that part, I'm okay.
Then we'll close it. Then you close it. Because without some submission, I don't think I would have written it in this manner. There was some submission, but on that day you were not there.
I was not.
You were not.
On earlier occasions, I was there. On that day, I was.
Either he himself said it or on a query by the court, he has said yes. Either of the two. But it can't be that without, and in any case, that is a disarming submission. That you don't affect me, I have nothing to say. So there is no direction to affect your clients.
No, it has got, Milord. Eventually, Milord, they'll be given seniority as per this. As per the para 14, they will get the seniority over us.
Then we'll clarify this.
Yes.
Okay, you take down. I heard Mr. K.N. Chaudhary, learned senior counsel, assisted by Mr. Yeg, learned counsel for the review petitioner. Also heard Mr. D. Gogoi, learned standing counsel, Forest Department, appearing for the respondent numbers. You are representing whom?
My
Respondent
lord,
number 1, 2,
1, my lords. 1, 2, 4.
But I'll still check it up. Because
I
if it has
personally
happened
checked
without any,
up.
then
I
it's
have personally checked up. That must I'm telling you.
1, 2, 4, 5, my lords.
check it up. Pull up the.
1, 2, 4, and 5. Respondent numbers.
1, 2, 4, and 5. Ms. P. Sharma, Learned Standing Council, APSC, for respondent number 6, and Mr. M. Sharma, Learned Council, appearing for respondent number 7 and 8. None has appeared for the respondent number 3. Full stop. This review petition is directed against the judgment and order dated 9/4/2024 passed by this court in WPC number 1148 of 2021, whereby certain observations were made which, according to the review petitioners, are not only incorrect on the face of the record, but tends to prejudice their interest. Hence this review petition. By referring to the observations made by this court in paragraph numbers 12, in paragraph numbers 12 and 14 of the judgment, 12, 14 and 15 of the judgment and order dated 9/4/2024, Mr. Chaudhary submits that although his clients were duly selected by the APSC as indicated in the select list dated 26/1989, yet on the basis of an erroneous submission made by the learned departmental counsel, the court proceeded on the basis that the review petitioners were never selected and therefore were not entitled to benefit of seniority by virtue of their higher ranking in terms of merit in the list of candidates who had successfully completed the training conducted by the
Concerned Forest College.
concerned forest college. First of it is also the case of the review petitioners that although OM dated 11/2/2020 was kept in abeyance by the subsequent OM dated 11/7/2020, yet the said aspect of the matter escaped the notice of the court, as a result of which a direction was issued in paragraph 15 of the judgment for fixing the inter se seniority of the 1989-91 batch of forest rangers by following the mandate of OM dated 11/02/2020. Hence this review petition, full stop. Mr. Chaudhary, learned senior counsel for the review petitioner, has argued that it is not correct finding of fact that the review petitioners were never selected by the APSC. Full stop. He submits that it is on account of operation of the reservation roster that the names of the review petitioners did not feature in the final list of selected candidates as notified by the government of Assam on 28/7/1989. Full stop. Therefore, it cannot be said that the review petitioners were never selected by the APSC. Full stop. On the question of determination of seniority of the forest rangers pertaining to the 1989-91 batch, here also Mr. Chaudhary submits that it is nothing else but the merit position of the successful candidates who had participated in the forest training, in the training conducted by the Forest Training College, that alone would matter. And the said position is consistent with the executive instructions issued by the government of Assam. Under such circumstances, the impugned order has caused serious prejudice to the interest of his client. Full stop. By inviting the attention of this court to the observations made in paragraph 13, whereby this court has recorded some form of concession by the petitioner's counsel not to object to the prayer of the petitioners if his client's interest is not affected, Mr. Chaudhary submits that such concession was misconstrued by the court, as it was never the intention of the petitioners to give a free run to the writ petitioners in the matter of fixation of seniority. However, in view of the observations made in para 13, the review petitioners would now be precluded from preferring an appeal before the division bench against the judgment and order dated 9/4/2024. Full stop. Responding to the above, Mr. Gogoi and a departmental counsel submits that the reflections made in the impugned judgment is based on what transpired in the court proceeding, and the submissions made on behalf of the department were based on the materials available on record. Full stop. He has, however, fairly admitted that the OM dated 11/2/2020 was kept in abeyance by the subsequent OM dated 11/7/2020. Full stop. It is also the stand of the learned departmental counsel that the inter-se seniority of ACF pertaining to the 1989-91 batch of forest rangers can be finalized after the service rules are notified. After the service rules, which are under examination by the APSC, are notified by the government. Mr. M. Sharma, learned counsel for the respondent numbers, private respondent, 9 and 10, is it? 7 and 8, on the other hand, submits that this court had passed the impugned judgment dated 9/4/2024 after a threadbare analysis of the facts and circumstances of the case, as well as the projections made before this court. Therefore, there is no scope for reviewing the judgment and order dated 9/4/2024. Full stop. After going through the materials and record, and after considering the submissions made at the bar, this court appreciates the contention of Mr. Chaudhary that notwithstanding the fact that the names of his clients were not included in the list of 18 selected stipendary forest rangers as notified on 28/7/1989, yet their seniority in the ultimate analysis would have to be determined as per the merit ranking of those candidates in the result published by the Forest Training College and not by the APSC ranking. Full stop. However, entering into an adjudication into said aspect of the matter would amount to rehearing of the writ petition, which would not be permissible in a review petition. Insofar as the observations made in para 15 of the judgment is concerned, here also, this court is of the opinion that there is a cosmetic, the error pointed out herein is of cosmetic nature, since it would always be open for the departmental authorities to rely and refer to the standing circulars and OMs while determining the inter-se seniority of the candidates. This is more so in view of the submission made by Mr. Gogoi that the inter-se seniority of forest rangers of 1989-91 batch can be determined as per the service rules, which are likely to be notified soon. First up, insofar as the objection raised by the petitioners, review petitioners, pertaining to alleged concession made by the petitioners' counsel, contending that such observations are coming in the way of the review petitioners in preferring an appeal, it is hereby clarified that such observations were based on the perception of the court, based on arguments addressed during the hearing of the court, and the same would not in any manner come in the way of the review petitioners preferring an appeal against the judgment and order dated 9/4/2024, if so advised. Mr. Therefore, without expressing any merit on the comment of the review petition, say even except observing that no sufficient cause for reviewing of the judgment and order dated 9/4/2024 is made out on the face of the record. His review petition stands closed by granting liberty to the petitioners to avail appropriate remedy as may be permissible under the law. Anything else? Mr.
That's,
Sodhi?
that's.
So you have a wider canvas and open it.
Absolutely.
Acha, respondent number 3, then Mr. A. Chakraborty. You can take this back.
Okay.
Well, today is the date fixed for consideration of my IA for the stay, my lord, because they are going to give my lord promotions, my lord, which I have categorically stated in my IA, my lord. So your lordship was pleased, my lord, on the last Monday, my lord, they sought time, my lord, to take instruction.
If I may submit, when this writ petition was pressed, my lord, when motion stays, my lord, they didn't press for any interim, my lord.
I
Just no
pressed-
discuss. Now, my
You
lord, they have
can't do
come-
this. You can't do this in this
Yes.
court.
Now
You
they
want
have-
to argue anything, you argue.
Now they
But
have
then you
come
sit.
with a IA.
Hmm.
Now, we have received instructions, madam. We'd like to file an affidavit in the main case, madam.
No, first of all, what is his, some
He's-
promotion is going to be
No,
given.
madam. He is a person who said, absorb me. He comes by absorption. He's not a direct recruit to that cadre. Now, since he's in a judgment, which is totally different, my lord, where it says that a person who is drawing higher salary is entitled to seniority. He's basing his arguments on that, and he wants his place to be, he was at the bottom. He wants his seniority at the top. But he was not a real basic direct recruit, my lord. He was absorbed into the cadre. He was doing a different job. He said that.
So what is the interim order you are seeking?
My lord, not to cause any, my lord, promotion. Basing on the gradation list until and unless my gradation list is taken into account.
Okay, so you are 100% sure that you will succeed.
My lord, because their own notification says so.
Mr. Yeah, you are 100%
Expectation
sure.
is always like
Huh?
this, sir, to be honest.
Now, if you give a bond of 5 lakhs, that if you fail, that will be forfeited,
Poor person.
then
cannot
we'll stop the promotion. Otherwise, it will be subject to further orders passed in the
get- Yes, that will do, man.
And when a private
That
parties
will do.
appear, private responses are there, they're like
That
to
will
file
do, my
response.
It will be subject to final order passed in the writ
Yes,
petition.
yes.
Well, I have been, so they'll like to file objection to this IML.
No, we'll close it by saying that promotion, if any given, will be subject to final order passed in the writ petition.
Yes.
That also you are not okay.
Since private respondents are there, madam, they might have.
All
to
right,
come
heard
to this
Mr. Jai Borboi, learned counsel for the applicant, also heard Mr. D. Gogoi, learned standing counsel, PhD department, Assam, appearing for the respondent, opposite party numbers. This will be
No,
applicants, huh?
1, 2, 3, madam. 1, 2, 3, 4, 5,
Opposite party numbers 1, 2,
3, 4, 5.
1 to 5.
1 to 5.
Mr.
Yes, Your Lordship, I am appearing for a private respondent, 6, 7, 8. However, Lordship, we have
S.
not
Borboi,
received a
learned
permit.
counsel for the opposite party numbers 6, 7, and 8. Full stop. The applicant herein is the writ petitioner in WPC number 4851 of 2024. He is presently serving as junior assistant
My lord.
in the office of chief engineer, bracket PHE, bracket close water, Assam, Hengrabadi, full stop. The primary grievance of the writ petitioner is pertaining to inter se seniority list, bracket gradation list of junior assistants. According to the petitioner, the seniority position assigned to him in the gradation list is erroneous. First step. During the pendency of WPC number 4851 of 2024, the writ petitioner as applicant has approached this court by filing the present application seeking an order of stay suspending the operation of the seniority list and also for restraining the where is the order not to promote anyone?
My lord.
This is no order.
Where is the prayer not to promote anyone?
There is, madam.
Well,
Suspend the operation of the inter se seniority list, bracket gradation list of junior assistants pending disposal of the writ petition. Full stop. Mr. Gogoi, learned departmental counsel, and Mr. So-and-so, learned counsel for the opposite parties have strongly opposed the prayer by contending that while moving the writ petition, no such interim relief was granted to the writ petitioner. Stop. As such, there is no scope for considering the prayer made in the IA. Full stop. After going through the materials available on record, I am in agreement with the submission of the learned counsel for the opposite parties. As such, this court is of the opinion that present is not a fit case for granting an interim order as prayed for by the applicant. The prayer is accordingly rejected. It is, however, made clear that any decision taken on the basis of the gradation list in question shall be subject to the final order that may be passed in the writ petition. With the above observation, I stands disposed of. You don't have any prayer.
That will do.
You don't have any prayer to
My
stop
lord, there is,
promotion.
my lord, if there is, my lord, direction authority.
Where is in the prayer portion, where have you mentioned?
Not to give, I did not.
That's what I'm saying. You don't have any prayer. That's it. Accept it if it is not there. Last item. Yes. What is this?
My lord, the petitioner, after a decade long of multiple litigation, this honorable court, while order dated 16/5/24, directed for my lord retrospective promotion. However, to defy this honorable court's order, they transferred me from my outside my cadre. The transfer order was dated 7/2/2025. We approached this honorable court.
What has happened? What is your instruction?
Lordship, regarding this matter, just yesterday, the petitioner has filed an additional affidavit in the IA, as well as an affidavit in reply into main writ petition. Lordship, we request 1 week's time. We'll obtain.
No, what has happened to communication dated 14/5 to 2025?
Lordship, regarding the 14.
Mr. Gogoi was supposed to obtain instruction.
Yes, Lordship.
Has it been withdrawn?
Yes, Lordship, it has been withdrawn.
Give him a copy.
This will not suffice.
First, let us deal with this, Mr. Patwari.
Yes, yes.
Whether it will suffice or not.
It is yesterday's letter.
It has been withdrawn.
It's a letter dated 3rd of June, 2025.
What was 14/5/2025?
That was what I am coming to, my lord. Lordship has stayed down my transfer order. However, they have not released my salary. So Lordship's order is dated 27.
Where is that order? 14/5/2025? Where is
Yes,
it?
Lordship, I filed an additional affidavit in that page 126. 126.
126.
In the IMN. Third para was the offending para.
So this has now been withdrawn.
Yesterday it has been withdrawn.
And what is the other problem you have?
Other problem is that, my lord, your lordship order is dated 27/2/2025. That is annexed in the.
That's not the problem.
No. Problem is non-payment of salary. That's why, despite your lordship being stayed the transfer order.
Correct. So today you have filed an additional affidavit.
Yesterday. Today I brought it on record.
What about his salary? Why aren't you paying it?
That we will need to obtain a proper instructions, Lordship.
No, is he not in service?
I do not have the information regarding that, actually, Lordship.
You will kindly bear with me 2 minutes.
But we'll give them 5 days time to obtain his.
Can you just give me 2 minutes time? But you will kindly come to page 134 of that same affidavit. It's a duty roster. I am a doctor, and a duty roster is prescribed month-wise. For the duty roster dated 31/2025, which is effective from 1st of February 2025, my name appears. Because the stay order is of 27/5, for the next month duty roster, my name has been stuck on. So from 1st of March 2025, the duty roster doesn't contain my name. Again, my lord, for administrative convenience, I am working in surgical oncological department. There also, prior list, my name appears. The subsequent list, my name is not there. And I have made a categorical statement. There are 2 biometric punching machines in the oncology department at GMCA. One is managed by the GMCA itself, where all the employees, they put their punch. I am daily going and punching there. And the other is, my lord, directly connected to the National Health Mission, erstwhile, my lord, Medical Council of India. Earlier, my lord, it was biometrics, fingerprint. Now from May, my lord, it has been being face-based. However, since my transfer was to Jorhat, which has been stayed, and the radius has to be within 100 meters, I am not been allowed to punch that because in the original record, they are showing my place of posting at Jorhat. That's why their lordship stay on. But these are the two main grievances, non-payment of salary.
So what is the order you are seeking today?
Well, the salary has to be paid. Their lordship's order is operating. You have stayed your lord, my transfer order. How can I not be my lord paid salary? They are saying that I have not worked, but the documents show they have stopped my work, but I am still going. They have cut my name from duty roster from March, my lord. And
All right, that's all?
yes.
Okay. Switch off the live streaming.